Hello all, welcome to Legal Talks by Desi Kanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about another judicial pronouncement by the Honorable Supreme Court of India in relation to the law of contract. It talks about acceptance of a conditional offer. In order to understand this, let us move on to the case at hand. The name of the case is Messrs. Padia Timber Company Private Limited versus the Board of Trustees of Vishakhapatnam Port through its secretary. In this case, the moot question that was answered by the court was whether the acceptance of a conditional offer with a further condition results in a concluded contract, irrespective of whether the offerer accepts the further condition proposed by the acceptor. Initially, this may seem like a very complex question, and in order to understand its background, we'll have to understand some of the provisions of the Indian Contract Act. So let us move to those provisions. All of us know that in the law of contract, there are two parties. The first party is the person that makes an offer, and the second party is the person who accepts that offer. And when this process is complete, a contract is said to be complete. But before a contract is complete or before a contract is entered into, there are many other stages as well. One such very important stage is communication. Now, Section 4 of the Indian Contract Act talks about communication when complete. It states that the communication of a proposal or an offer is complete when it comes to the knowledge of the person to whom it is made, that is the acceptor. So when the proposer or the offerer sends his or her proposal to the acceptor, and as soon as it comes to the knowledge of the acceptor, the communication of that proposal is said to be complete. Let us understand this with the help of an example. A wants to enter into a contract with B. A sends a letter to B indicating his proposal. As soon as that letter is received by B, the communication of that proposal is said to be complete. Now let us move on to the second limb of this section. The second limb of this section talks about communication of an acceptance. When is the communication of an acceptance said to be complete? This communication of an acceptance could be divided into two parts. The first part is in relation to the acceptor and the second part is in relation to the proposer. As soon as the acceptor sends his or her acceptance to the proposer, and as soon as it is transmitted, the communication of that acceptance is complete on the part of the acceptor. The acceptor can say that on his part, the communication of acceptance is complete. He has completed his part of the deal in relation to the communication of acceptance. Now, with respect to the proposer, as soon as the proposer receives the acceptance of the acceptor, or as soon as the proposer gathers the knowledge about the acceptance of the proposer, he could say that communication of acceptance on his part is also complete. Thus, both these conditions need to exist in order to have communication of an acceptance. Let us understand this with the help of an example. Suppose A wants to enter into a contract with B. A writes a letter to B indicating his proposal. B receives that letter and B decides that he will accept the proposal of A. So B sends a letter to A indicating his acceptance. He sends that letter by way of speed post. As soon as B has sent his acceptance letter by way of his speed post, he can say that communication of acceptance is complete on his part. And as soon as A receives that letter by way of speed post, the communication of acceptance is complete on his part. And when both these contingencies happen, the communication of an acceptance could be said to be complete. Similar is the case with the communication of a revocation. When a person sends his revocation, his part is done, and when the person to whom that revocation is sent gathers knowledge about the revocation, the communication of revocation is complete on his part, and when both these contingencies happen, the communication of a revocation could be said to be complete. Now let us move on to section 7, which is another section that was dealt with by the court in this case. Section 7 talks about acceptance must be absolute. It talks about the contingencies that convert a proposal into a promise. As I stated earlier, the proposal is sent by the proposer or the offerer, and when does that proposal convert into a promise? In order to have a contract, for converting a proposal into a promise, the acceptance must be absolute and unqualified. What do we mean by absolute and unqualified? That there must not be any conditions attached to the acceptance. The second condition in section 7 is that in order to convert a proposal into a promise, the acceptance must be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. Now let us understand this with the help of an example. Suppose A wants to enter into a contract with B. Both of them live in India. A sends a letter to B in Hindi language indicating his proposal. B decides to accept it and writes his acceptance letter to A in French language. And he does that after a period of 1 year of receiving the proposal letter by the A. So here, expression of acceptance is quite unusual. B has decided to send his acceptance which is not understood by A, and B has sent his acceptance after a very long period of time, after a period of 1 year. So such expression of acceptance cannot be called as usual or reasonable. Thus, such an acceptance will not convert a proposal into a promise. The court in this case discussed section 4 and section 7 and said that existence of offer and acceptance of an offer must be absolute, and it must be founded on 3 components: certainty, commitment, and communication. Thus, in case the acceptor puts in a new condition while accepting the contract that has already been signed by the offerer, the contract will not get completed until the offerer accepts the new condition. Now, the court also discussed the jurisprudence behind acceptance of a contract. The court cited the case of Raghunandan Reddy versus the state of Hyderabad. In this case, it was said that it is a well-established principle of law that only when an offer is accepted that the contract is concluded and binds the parties. It is equally well settled that before an offer is accepted, the offerer can withdraw his offer, but if the acceptance is conditional or is not final, then there is no concluded contract. The second case discussed by the court was Haridwar Singh versus Bagun Sumbrai and others. It is a 1972 Supreme Court of India judgment. In this case, the court said that an acceptance with a variation is no acceptance and is simply a counter proposal that is required to be accepted in toto by the original proposer before a contract is made. These are very important words, that an acceptance with a variation is no acceptance and it becomes a counter proposal. Lastly, the court cited the case of Union of India versus Bhimsen Valeti Ram. In this case, it was held that acceptance of an offer may be either absolute or conditional. If the acceptance is conditional, offer can be withdrawn at any moment until absolute acceptance has taken place. Thus, when the acceptance is conditional, the offerer is at a liberty to withdraw his offer until there is absolute acceptance. Finally, the court concluded by stating that in response to an offer where there is conditional acceptance which is not agreed upon by the offerer unconditionally, then it could not be said that there was a concluded contract, and when there is no concluded contract, there is no question of any breach of that contract or any damages arising out of that contract. This is a very welcome judgment by the Honorable Supreme Court. The parties must take the words spoken or written by each other at their face value. They must not add or subtract anything into it. And it also gives an important lesson that acceptance of any offer has to be unconditional. And till that happens, as I stated earlier, the parties must not assume that there exists a concluded contract. It could be said that the acceptance of a conditional offer with a further condition does not result in a concluded contract, irrespective of whether the offerer accepts the further condition proposed by the acceptor. I hope that you found this case to be interesting, and thank you very much for listening to this stream. Stay tuned.